Hello, everyone. Welcome to another episode of the UPC Insights, where we delve into the latest developments in patent law. I'm your host, George Walden. As always, today we're exploring a landmark decision by the Court of Justice of the European Union, the CJEU, in the case of the BSH Hausgeräte GmbH versus Electrolux AB. This ruling has significant implications for cross-border patent enforcement within the EU and beyond. Joining us are two distinguished guests. First guest today is new from our show. His name is Mario Pozzi, an Italian patent litigator and UPC representative from SIBlex. And let me give you a little bit of background on Mario. Mario is an expert in intellectual property law with a particular focus on Italian, pan-European, and cross-border patent litigation, including proceedings before the Unified Patent Court, UPC. His practice is centered on patent litigation and strategy, especially in the mechanical, telecommunications, and pharmaceutical sectors. Mario's clients include leading Italian and international companies from various industries, and he brings extensive experience in advertising clients on complex IP negotiations and high-stakes litigations. A frequent speaker at intellectual property conferences, Mario also lectures at universities and contributes to specialized journals, and he is an active member of the LES and the AIPPI. Ladies and gentlemen, without further ado, please welcome Mr. Mario Pozzi. Mario, welcome to the show.
Thank you, George. I'm very pleased to be here today.
We're very glad to have you. We always try to get the best guests, and definitely you're one of them. So, and then we, of course, have our mainstay, the man who makes it all happen, Mr. Tilman Pfrang. Tilman, welcome to the show.
Hello, George.
Tilman is also represented from Meissner Bolte, and we'd like to welcome both Mario and Tilman, and let's dive straight into it and get into all the good questions that we have for you this afternoon. Tilman, could you provide us with an overview of the BSH versus Electrolux case and the CJEU's ruling? Now, this is going to be interesting.
Of course, George. In a nutshell, the case involves BSH, a German company holding a European patent validated in multiple EU countries and Turkey. BSH alleged that Electrolux, a Swedish company, infringed these patents across several jurisdictions. And Electrolux then contested the action, arguing that the patents were invalid and that the Swedish courts lacked jurisdiction over infringement claims concerning patents validated outside Sweden. Very recently now, the CJEU ruled that a court in an EU member state where the defendant is domiciled, so this is important, where the defendant is domiciled, has jurisdiction over infringement actions concerning European patents validated in other member states and even in non-EU countries like Turkey. This, according to the CJEU, holds true even if the defendant raises a validity defense, as long as the primary subject of the proceedings is infringement, patent infringement, and not the validity of the patent.
Okay, so that's a significant expansion of jurisdiction. So, Mario, from your perspective, what are the practical implications of this ruling for patent holders and defendants in the EU?
Well, thank you, George. First of all, I believe that national courts, or the UPC, when acting as the court of domicile, so the courts where the defendants are domicile, will have jurisdiction over the infringement of all portions of EU patents. And even if defendants raise an invalidity defense, the national courts or the UPC will still have jurisdiction to hear and decide on infringement claims, including injunctions and damages for all portions of the EU patents. However, from what we learn from the CJEU decision, depending on the specific portion of the EU patent in question, the national courts or the UPC may decide on validity issue with erga omnes effects, or be unable to decide on validity and consider staying the proceedings, or assess validity with inter partes effects.
Okay. Tilman, how does this ruling interact with the exclusive jurisdiction rule under Article 24.4 of the Brussels 1 bis regulation, which traditionally grants jurisdiction to the courts where the patent is registered?
Yeah, that's the key question, George. Article 24.4 of the Brussels regulation provides the courts of the member state where a patent is registered have exclusive jurisdiction over cases concerning the registration or validity of that patent. However, the CJEU clarified now that this exclusive jurisdiction applies only when the principal subject matter of the proceedings is the validity of the patent. In cases where infringement is the primary issue, and validity is raised merely as a defense, the court of the defendant's domicile retains jurisdiction to rule on the infringement claim, and even with inter partes effect on the validity of the patent. This intends to prevent defendants from avoiding litigation in their home courts simply by challenging the patent's validity, of course.
Okay, so this is a good question then for Mario. Considering this ruling, what strategic considerations should patent litigators keep in mind when planning cross-border enforcement within the EU?
Well, basically, national or UPC proceedings, in my opinion, will have different speed depending on the portion of the EU patents involved in the litigation. So let's make an example. If a German company sues an Italian company for the infringement of its European patent, of course not opted out before the UPC Milan local division, which is the court of domicile. And let's assume that the patent has been validated in Italy, Germany, France, Netherlands, which are all UPC contracting member states, plus Ireland and Spain, which are EU member states, but not UPC contracting member states. And so let's assume that the defendant, as frequently happens, raises a counterclaim for revocation of the above portions of the European patent. So we will have Article 24.4 of the regulation of the Brussels regulation recast, which shall apply for Ireland and Spain, since, of course, this regulation does apply to EU countries, whereas Article 24.4 will not apply to CMS within the contracting member states country. So the UPC Milan local division will assess the infringement and the validity erga omnes of all the contracting member states portions of the European patent, whereas with respect to Ireland and Spain portion, the Milan local division will assess only, so to say, the infringement and damages for Ireland and Spain portions. And to use the word of the CJEU, if it considered justify the invalidity defense, the UPC Milan local division may also stay the proceedings with reference to those portions of the European patent.
Very well explained. Very good. Tilman, how might this decision impact the role of the Unified Patent Court, the UPC, in handling cross-border patent disputes then?
Yeah, in a kind of a positive way, I would say the UPC as such is designed to provide a centralized forum for patent litigation, offering uniform decisions across participating states so far. And this CJEU ruling now complements the UPC's objectives by allowing national courts to handle, or also the UPC to handle, certain cross-border infringement cases, especially when the defendant is domiciled in an EU member state. However, the UPC has exclusive competence over classical European bundle patents, such as patents validated in Italy, Germany, and so on, and unitary patents in the participating states, which may limit the application of this ruling within the UPC framework. Düsseldorf so far has said, no, it does not limit the application of this ruling. We will see. In any case, patent holders will need to strategically decide whether to pursue actions in national courts under this new precedent or opt for the centralized approach of the UPC, considering factors like the scope of infringement and the jurisdictions involved.
Okay, it's always Düsseldorf, isn't it?
It's always Düsseldorf. Sometimes Mario. It's Munich. and very often it's Milano.
Yeah, now Milan. Yeah, we got them in there too, right? Mario, so far, we focus on the implications of this decision within the territory of the European Patent Convention, the EPC. However, I noticed discussions emerging about whether the CJEU ruling could open the door for the UPC to decide on non-European patents, such as the US or Chinese patents. Do you think we might see the UPC actions in the future where plaintiffs seek judgments concerning the infringements of the US or Chinese patents?
Well, George, I don't think so. The entire discussion revolves around EU regulations or other conventions, such as the Lugano Convention, and how they apply in the case of European patent, which, as everyone knows, include countries outside the EU, such as Turkey and UK. But at least, however, we are talking always about the European Patent Convention and of European patent. I do not believe that the jurisdiction of national court or the UPC, which according to the Brussels regulation recast is essentially the same thing, so could extend so far as to assess the infringement and damages of a US patent or a Chinese patent. The UK and Turkey, as well as Cambodia, for example, are linked to the EU countries through the European Patent Convention, whereas the US, China are not. Moreover, in its decision, the CJEU emphasized the importance of not violating the principle of non-interference, according to which a state may not interfere in cases that essentially fall within the national jurisdiction of another state. And beyond that, even if the UPC were to extend its jurisdiction to the US or China, I highly doubt that US or China courts would recognize or enforce the UPC's decisions.
Very interesting. Then, Mario, are there any potential risk of forum shopping resulting from this decision, and how might courts mitigate such risk?
Well, basically, I believe that the court of domicile will be used more often and primarily to obtain broader decision on infringement, injunction, and damages. However, I expect that certain portions of EU patents may be excluded from some action to avoid the risk of the court staying the proceedings. Returning to the above example I previously mentioned, patent litigators may choose to exclude the EU portion of an European patent, such as those in Ireland and Spain, for example, for which Article 24.4 of the Brussels regulation recast applies, while including the EPC portion, such as the UK or Turkey patents. This is because the CJEU has determined that the court of domicile seized, in the case I mentioned was the UPC Milan local division, can also assess the validity of such portions, albeit with an inter partes effect, as Article 24.4 of the Brussels regulation recast does not apply for the EPC portion of the European patents such as UK or Turkey.
Okay, the EPC seems to be a theme there. Tilman, how do you expect the UPC to interpret and apply the CJEU decision in its practice? And do you foresee any immediate changes in how the court handles representation and admissibility issues?
Yeah, actually, George, the UPC has already more or less kind of proactively extended its jurisdictional reach in ways that align with the CJEU's recent decision, as if they would have anticipated it more or less. For example, the UPC's local division Düsseldorf asserted jurisdiction over alleged patent infringements occurring in the UK, despite the UK's non-participation in the UPC system. The Düsseldorf division based its jurisdiction on the defendant's operations across multiple EU jurisdictions in that case, covered by the UPC, allowing it to adjudicate related claims beyond the immediate scope of the UPC agreement. Similarly, the Helsinki local division, a very famous case, by the way, addressed also jurisdictional challenges involving non-UPC member states. In this case, where the claimant sought to include acts allegedly committed in Spain, a EU member state, but not a UPC member state, the Helsinki division accepted the request, emphasizing the need to avoid conflicting rulings from separate courts. And eventually, the Mannheim division, which had previously taken a much more cautious approach, has now, at least acknowledged the CJEU ruling and decided to separate the proceedings concerning the non-UPC member states in that case. However, the primary reason for not proceeding with these jurisdictions was not a fundamental opposition to the CJEU to extending jurisdiction, but rather a procedural concern. Specifically, In this case, the CJEU decision was published only after the main hearing had taken place in Mannheim. So to avoid infringing the parties' right to be heard, the Mannheim division opted to separate the proceedings rather than retroactively applying the ruling without allowing further submissions. But also in Mannheim, I'm quite certain is maybe a strong word, but I think there's a high probability that they will follow the guidance of the CJEU. In the end, in principle, they must.
So then, before we conclude, are there any final thoughts you'd like to share on the implications of the BSH versus the Electrolux decision?
Well, basically, I think that the CJEU decision create more a more intricate landscape for patent litigation, because of course you have to consider different portion of the EU patents and how the UPC or the national court could react if these portions of the European patents are or not involved. At the same time, for those of us who know the rules, I think that the patent litigation, so to say, chess game will become increasingly interesting. So let's see.
I mean, Mario, so then I have a quick question for you. With the CJEU decision, are you in agreement with the direction in which it's going? Do you have any apprehension towards the way it's shaping, or are you pretty happy with the way things are looking so far in that direction?
I think I'm pretty happy. I'm pretty happy. So basically, they follow also the Advocate General Emily opinion. I think more the first one opinion, because there were two opinion of the Advocate General, and it is coherent also with some previous case law. The gut look said, okay, you have exclusive jurisdiction. The member states court of the EU do have exclusive jurisdiction over the validity and the registration of the national portion. And the CJEU said clearly that if the validity is involved, the national court cannot assess the validity, or at least they can assess on a preliminary basis and decide to stay the proceedings, but not with an erga omnes effect. So they respect this non-interference principle. On the other hand, they clearly apply the EU regulation, the Brussels regulation recast, and they clearly say the Article 24.4 does not apply to the EPC member states which are not part of the EU, so Turkey and UK, which is coherent, in my opinion, with the scope of the Brussels regulation recast. So I'm pretty happy. I'm still thinking about it.
Fair enough. Fair. Tilman, you have anything to add to that?
No, I'm very happy to. I have touched this point. I mean, it will be interesting to see how the UPC divisions will actually deal with this decision. There is the one point that actually Article 34 of the UPC agreement might even lead to a narrow interpretation, which is still in line with the general objectives of the CJEU decision. But also there, as I said, Düsseldorf said, no, there's no issue with Article 34 of the UPC agreement.
Right. Well, with Düsseldorf, it's always the question there. So I'd like to thank you, Tilman and Mario, especially for having taken the time out to join us today. And it's great to have you as a guest, and maybe in the future, I would love to have you back. And thanks for sharing your insights on this landmark decision. It's clear that the BSH versus the Electrolux ruling will have a profound impact on the patent litigation strategies within the EU. To our listeners, we hope you found this discussion enlightening. Stay tuned for future episodes of the UPC Insights, where we'll continue to explore pivotal developments in patent law. If you have any questions or topics you'd like us to cover, feel free to reach out through our website. Until next time, this is George Walden signing off with Mario and Tilman. Until next time, auf Wiedersehen.
Auf Wiedersehen. And arrivederci.
And arrivederci.
Thank you, George.
Ciao, guys.
Ciao.